Hello everyone and welcome to this video tutorial on how to apply the law on express terms to a contract scenario. In this tutorial we're going to be looking at the Florence and the TVs Are Us mini scenario. We'll recap the law on express terms and we'll look at how you would use IDEA to apply express terms to a scenario. Terms in contracts is a very big topic, so we're breaking it down and looking at express terms and implied terms and exclusion clauses in separate video tutorials. So make sure that you watch all of the tutorials on this area. So as I say, today we're going to focus just on the express terms. As always, let's start by looking at the scenario that we've been given. So the situation is this: Florence has bought a new TV aerial from TVs Are Us, who assured her that it would be perfect for improving the quality of her television reception. Florence arranged for James to install the aerial, and the aerial made her reception worse. And you're being asked to advise Florence on whether the statement is a representation or a term. So this is quite a nice question because it's actually telling you what area of contract law you should be applying to this scenario. And specifically, it's telling you here that it wants to know, is it a rep or is it a term? And that's what express terms is all about. So the issue here relating to this question you're being asked whether the statement is a rep or a term. So the statement here is that the aerial is going to be perfect for improving the quality of a TV reception. And it turns out that statement is incorrect because the aerial made her reception worse. And she needs to know, is that statement a rep or is it a term? And the reason for that, hopefully you remember from studying this area, if it's a representation and it's false, she can claim in misrepresentation. But if she can prove that that pre-contractual statement is actually a term, that's better for her because she'd have a claim in breach of contract. And that's why she wants to know what classification this statement is. So I think this would be a good point for us just to recap what the law on express terms is. So I've got a summary slide here just on express terms. I do recommend that you make sure that you've watched and maybe rewatched the separate video tutorial where I just go through all of the law on express and implied terms, just to make sure it's really fresh in your mind before you try and apply it. This is only going to be a very quick recap, and today we're just focusing on express terms. But remember, for the topic of contract terms, you need to know about express terms, implied terms, and also exclusion clauses. But for our quick recap then, let's just have a look at a definition of express terms. Express terms are the terms that are agreed on by the parties to the contract, preferably in writing. Implied terms, which we look at in another video tutorial, are terms that haven't been agreed on actually by the parties, but they've been implied or put into the contract by the courts or by a statute such as the Consumer Rights Act. But express terms are ones that are expressly agreed on by the parties. And as it says here, preferably in writing. So we hope that all the terms of the contract that have been agreed on are going to be written in the contract. But of course, in the real world, there will be parts of the contract that are spoken in the run-up, in the negotiations before the contract's actually finalised. And if terms appear to be orally agreed, so there's been verbal discussion, there's been a verbal statement made, like in Florence's case, we need to determine whether it's a rep, in which case you'd claim for misrepresentation if it was false, or whether it's a term, in which case you've got more rights and you can actually claim for breach of contract. So in order to decide whenever you've got a pre-contractual statement being made, there are a number of rules that we have to look at to decide, is it just a representation or is it a term? And we looked at this in a previous video tutorial in detail where I went through all these cases with you, but it's quite nice and straightforward, this area. We look at the importance of the statement, knowledge and skill of the person making the statement, and the timing of the statement in terms of when the contract was actually agreed. These rules that we use are quite straightforward. Importance of the statement means that if the statement was of such importance that the claimant would unlikely have contracted without that guarantee, then the presumption is that the statement will be a term. And that was shown in the case of Bannerman when he was buying hops, if you remember. We also look at knowledge and skill of the people making statements. If the individual making the statement has some specialist skill or knowledge of the contractual subject matter or claims to have such knowledge, the presumption is that the statement is more likely to be a term. But conversely, of course, if the claimant is in a better position to ascertain the truth about the thing that they're purchasing, then it's less likely to be a term. We also look at the timing that the statement was made, and that's shown in the case of Routledge and McKay. It shows us that the closer that the contract was concluded in relation to the statement being made, the more likely it is to be a term. So these are guidelines really for working out whether a statement is likely to be a representation or a term or not. So now that's fresh in our mind, let's go back to the Florence scenario and have a look at what we think here. So our statement was that this aerial would be perfect for improving the quality of her TV reception. Clearly, that's going to be an important statement to Florence because her whole purpose of buying the aerial is that she wanted to improve the quality of her TV reception, and she'd be very unlikely to buy it if she'd known it was going to make it worse. So it's an important statement to her, making it more likely to be a term. When we consider the parties' positions here, Florence presumably doesn't know anything about aerials, whereas TVs R Us are presumably experts in TV aerials and they possess specialist skill and knowledge on this subject matter, and she's likely to rely on any statement that they make about aerials because she's not in a position to verify that. So again, more likely to be a term. And then we're not given too much information about the timing, but it seems like very soon after they made this statement, she arranged for James to install it, the contract was concluded. So using all three of those guidelines, it certainly seems that that should be an express term of the contract. So that's the answer that we want to be writing, but let's have a look at the idea structure as it applies to express terms so that we can make sure we're maximising our AO1 and our AO2 marks. As always, we use idea, we identify, define, explain and apply. So to start off with, you need to identify that your claimant, in our case Florence, needs to establish whether the oral statement made by the defendants, in our case TVs R Us, has been validly incorporated into the contract as an express term rather than being a mere representation. We then define what an express term is. So I've put the term set out the obligations under a contract. They can be express or implied. For us, we're concerned with express, so that's what I've defined here. Express terms are agreed by the parties themselves. Ideally, they'll be written down, but where they're agreed verbally, it has to be established whether the terms of the contract or representations. And in your E here, you're simply going to explain that explain the rules that we use to work out whether it's a term or a rep. So explain importance with your case, explain knowledge, explain timing. And there's not an awful lot to write here on express terms. You'll probably find that in the real exam, it won't just be on express terms. There'll be some express, some implied, maybe an exclusion clause as well. So that's why there's not very much to write here. We're doing a mini scenario, but in the real exam, you will have other areas to look at as well. But as we've not got that much to write about here on express terms, do make sure that you explain your cases fully so that you show you fully understand the rule. And in terms of your application, firstly, you should say what's the statement that needs to be examined. Now, in our scenario, it's pretty obvious because we've got a mini scenario, but in the exam, you're going to have a long scenario. There might have been lots of things said. So you need to say which statement needs to be assessed as to whether it's a term or a representation. And just as we talked through a minute ago, apply the importance of the statement to your claimant. Apply knowledge of the parties to your claimant and defendant, so you're saying who's in the better position to know the truth. Apply the timing of the statement, so look at best you can when it was made. Even though we don't specifically know from our Florence scenario, you can still say it doesn't appear that there was a big time lapse. And then you're going to conclude on whether it's more likely to be a term, so breach of contract, or representation, claim for misrepresentation. My next slide, I've done a bullet point answer to the Florence scenario. We've already sort of gone through the I, the D and the E here. Let's just focus on what I've said in my application. Mine's very listy, bullet pointy, so I could fit it on one slide. In the exam, you should obviously be writing fully, and when you're mentioning a case, really make it clear why that applies in your situation. So in my application, I've started off by saying what statement needs to be looked at. So TVs R Us assured Florence that the aerial would improve her TV quality. That's the statement we need to look at. The information is likely to be a term if it's important to Florence and she's relied on it, Bannerman. And I've said it seems unlikely that Florence would have bought the aerial had this statement not been made, suggesting it's a term. TVs R Us possess the superior knowledge and skill, again suggesting it's a term, so you can apply Dick Bentley there. And the statement was made, it looks like, just before she bought the aerial, that should say. Let me just correct it on there for you. So the statement was made just before she bought the aerial, again suggesting it's a term using Routledge and McKay. So therefore, it's likely the statement was a term, and she therefore can claim in breach of contract. So I hope that's been helpful in setting out how you should apply the rules on express terms to a scenario. As I've said, terms is a really big topic in contract law. And although we've just focused on applying express terms, it's likely that in the real exam you'd do some express terms, maybe a bit of implied terms in there as well, maybe an exclusion clause as well. So please do watch my next video tutorials on how to apply the law on implied terms and how to apply the law on exclusion clauses so that you're able to do an idea on each of them if they all appear together in a scenario.